Hearing in the appeal, the Queen against Andrews.
Mr. Brown. I understand you have a difficulty and have a motion to make. I will want to hear the circumstances that have arisen, and yes. I'd also clearly wish to hear from counsel for the respondent in relation to the matter. I should indicate that the court would wish, if possible, for the case to proceed, if possible, but and would certainly be willing to allow you some time. But let me hear how serious your predicament is, because we've all been counsel at the bar, and this is not something any of us would have wished to happen to us.
My Lord, well, I'm grateful for that indication. The position is that I was informed about 7:45 this morning that Mr. Evans is not well. He didn't go into, he sounded unwell, he didn't go into a great deal of detail, save to indicate that he'd had about an hour's sleep. He has spoken to a doctor who has indicated that he is not fit, in the doctor's view, having confirmed what his symptoms are. I'm afraid I'm not able to assist the court any further as to the extent of his illness or what that might be, save to say that I know this court has had previous dealings with Mr. Evans. I also know that he has been working on this case night and day for the last 3 weeks. And so this isn't an application that is made lightly. The difficulty that I am faced with, and putting cards on the table, is that Mr. Evans was instructed in the Court of Appeal to deal with the appeal on the basis that he is a confiscation specialist. In terms of the way that we have, again, as I say, cards on the table, the way that we've prepared this case is that Mr. Evans has very much been front and centre in terms of its preparation, and I have very much acted in a supporting role to the extent that I am not in possession of an opening monologue, such as it is, or a speaking note. I have, and in the course of my preparation, done some notes in an effort to assist Mr. Evans. It is a position that I, for my own part, find somewhat galling. I accept that I am of sufficient seniority to be able to present a case of this nature. Having said that, this is a case, as certified by this court, of general public importance. I know, and I'm conscious of the fact, that there are a number of agencies in the addition to the Crown Prosecution Service who await with interest the judgment in relation to this particular matter. And so, whereas perhaps in a lower court I would proceed with a degree of more confidence in relation to that, that is not the position I find myself here, and I would be concerned, as I think I indicated in my email correspondence, that I would not be doing justice to this case, bearing in mind the state and my level of preparation based on the way that we'd approach this case on a collective basis. That may be something that I need to take on board going forward in terms of the way that I prepared this case, but as I say, that is the way that we agreed to carry on the work, and that is it. If the court is minded to go ahead, as I said, I will do the best that I can, but I do not feel this is a case where the merits of it is simply a case of doing the best that one could. I would not feel entirely comfortable, but I would, if called upon, I would obviously do my best.
Yes.
You were fully prepared in preparing the written case, were you?
In terms of preparing the written case, Mr. Evans wrote the written case. I added my comments to it.
You appeared below?
No, Mr. Evans appeared below in the Court of Appeal. But I appeared in the Crown Court, yes.
Yes.
I hope that's a full and frank summary of the position I find myself in.
Yes. I mean, would there be any prospect, if we were to adjourn for a while, for you to obtain Mr. Evans's speech notes and have an opportunity to consider them?
I can certainly try to do that. I don't know whether it's in the form, I confess, in the way that I would write it out, pretty much in full, or whether it's very much his own personal style.
Yes.
Can I say this, that I am not, having already said I'm not comfortable in terms of presentation, I'm also not comfortable in not saying that I'm ready to proceed, because, as said to you by many a Crown Court judge up and down the land, you're the junior, now get on with it.
Yes.
And I take that point.
But this is somewhat different, I fully accept.
This is not a case where, as I say, it's a matter, for example, not the saying that they are not of significance, but
yes.
one would have a degree more confidence in proceeding.
Yes, well, you can take it that the panel have read the judgments below and the written cases, so
yes.
we know what it is the parties are saying.
Yes.
And you can also take it that we have had a pre-hearing discussion, and it is likely that we will wish at some stage to be addressed on whether or not there is a middle way between all or nothing. And that may be something on which we request further written submissions to which Mr. Evans can contribute.
Yes.
And that will have some influence on our decision whether or not to proceed. But thank you very much. I will hear from Mr. Ashley Norman.
My lords, the court is seized with attention, and there's probably little I can add to unfold it to your lordships. I indicated to my friend that we would be neutral in the position. A closer reading of the papers would reveal that Mr. Evans and I have crossed swords or sparred together on a number of occasions. And to know Mr. Evans is to like him and to accept, of course, that if he's incapacitated, then that is of great concern. So other than being neutral, of course, we have arrived anxious to make our representations to this court.
Yes, but you're taking a formal neutrality.
We're taking a formal neutral stance.
Thank you very much. Well, I think the appropriate thing to do is that the court will adjourn to consider your submission.
Thank you.
Mr. Cameron Brown, the court is very sympathetic to your predicament, but we do wish this appeal to proceed. In order not to put you in a more difficult position than you find yourself, we are content now to adjourn until 11:30, so you can perhaps speak to Mr. Evans and, if possible, obtain and consider his speech notes.
Yes.
What I would propose is that the court will sit this afternoon to 4:30, and that the lost time, which will be reasonably short, be shared between the two parties.
Thank you, my lord.
Thank you.
I think that's the appropriate way to proceed. So the court will now adjourn, and we will resume at 11:30.
Thank you.
Thank you.
Well, my Lords, I'm very grateful for the extra time afforded to me. Can I say, just by way of update, I've attempted to speak to Mr. Evans. I think it's fair to say Mr. Evans is going to hospital.
Oh, I'm sorry.
And in the circumstances, I think it's unlikely he's going to be able to forward me anything in terms of any notes or anything of that matter. So I don't have any speaking note that certainly that he's prepared. Can I mention two other matters? I've invited, and I hope it's not inappropriate for me to do so, for Mr. Bryan, who has higher rights, to sit to my left. He's an experienced confiscation lawyer, and it may be that in the course of questions, he's able to assist me at that point. I wanted to raise it and introduce him because I appreciate he hadn't me listed as one of the advocates. Can I also say I'm grateful for the indication that we would have an opportunity to make written representations as to whether there is a halfway point that could be reached between the parties. Can I also invite this, that if there are questions that I am struggling to answer, that in due course that we give an opportunity to respond with the input of Mr. Evans, if that is acceptable to the court.
It is. I mean, what I'm thinking of is if the court were to take the view that the sale decision was correctly decided, and if the court were to take the view that while the respondent did the job to a high standard, but nevertheless what the employers had been wishing to recruit and engage in employment was an honest and upright person, and they may have suffered considerable embarrassment as a result of what they actually got. Whether in those two circumstances there is a middle way that can be fashioned. I'm not saying that the court has reached any concluded view at all, but it's something that really isn't focused in the parties' cases, and that's why I'm recognising that may be something that will be appropriate to have written submissions, particularly in the predicament in which you find yourself. I think it might be a bit unfair to expect you to cope with that here and now.
Well, I'm grateful for that indication. And can I say I'm also grateful for an indication that the court has read everything. If I say anything where repetition is involved, can I apologise for that in advance? I'm not clearly seeking to.
No.
It is one of the, apologise for cutting across here, it is one of these cases where perhaps we place more heavy reliance, bearing in mind the circumstances in which I find myself, on what we've committed to paper.
Of course.
As opposed to what I say before you.
Could I also indicate, just before you start, that subject to how matters progress, I would propose that you should be able to speak till 2:15. Thereafter, the respondent from 2:15 to 4 o'clock, if that's acceptable, and then you'll have a reply from 4 o'clock to 4:30. If you're finding that you need more time, we can, if both parties need more time, we can, if necessary, shorten the lunch adjournment.
Yes, I think I can say openly for my part that it's a question of I don't think I'll need that amount of time.
No.
Bearing in mind the amount.
Well, it is a very focused issue we're looking at.
Thank you very much.
Thank you.
Starting then with, if I may, with the question posed to this court, where a defendant obtains remuneration as a result of or in connection with an offence of fraud upon the attainment of employment by false representations or non-disclosure, in what circumstances, if any, will a confiscation order based on the wages earned be disproportionate within the terms of Section 6.5 of the Proceeds of Crime Act 2002, or contrary to Article 1, Protocol 1 of the ECHR? And our direct and straightforward answer, if it is that, to that question is that would only apply where there has been actual restoration of the wages. In other words, and only in those circumstances where there's been actual restoration of the wages would it be disproportionate. Just looking at that question, I think it can be broken down into two parts. So in other words, where a defendant obtains remuneration as a result of or in connection with an offence of fraud. Just looking at that part, I think it's fair to say that the respondent properly concedes the first part of that, notwithstanding a basis of plea setting out that in fact that he worked for good value for 10 years, because we say the offence he pleaded to in effect left him with little choice. It was obtained as a result of or in connection with an offence of fraud. And it's also accepted, by not taking that point, or certainly that point being ruled away by the Court of Appeal, that it was a continuing and operative deception. And so in those circumstances, we would argue that it would, in the particular circumstances of this case, sorry, forgive me, I'll start that again. In those circumstances, they argue that it would be disproportionate to allow confiscation. I am sure that having read our statement of case, that the general principles that we rely upon are clear to your lordships. But to taking them in each part, we say this is not a case of genuine restoration. The work, if it can be called work, that Mr. Andrews did is part of his criminal offence. Restoration would involve restoring the actual salary, which did not occur. Public policy, and indeed authority, and including in that I mean by that wire, supports the proposition that does not allow the deduction of the costs of committing a criminal offence in determining the value of an individual's gain. And we say this is a case that falls into those third categories of wire as set out, and I think it may be just easier for present purposes, certainly for my purposes, if I take you to the relevant part at paragraph 29 of our skeleton. Where really the heart of this appeal and the issues presented are set out. And as set out there, at paragraph 20, quoting paragraph 20, the difficult question is when a confiscation order may be disproportionate. And it goes on at paragraph 26 there to set out 3 examples of where a legitimate proportionate confiscation may have one or more 3 effects. A, it may require the defendant to pay the whole of a sum which is obtained jointly with others. B, similarly, it may require several defendants each to pay a sum which has been obtained successively by each of them, as where one defendant pays another for criminal property. And lastly, and where we say this case falls onto, it may require a defendant to pay the whole of a sum which he has obtained by crime without enabling him to set off the expenses of the crime. And it goes on to say that these propositions are not difficult to understand. And I think the difficulties expressed by the recorder in the court below is that what was required of him was in effect to embark, as suggested here, upon an accounting exercise in which the defendant is entitled to set off the cost of committing his crime, which would be to treat his criminal enterprise as if it were a legitimate business, and confiscation a form of business taxation. And then it gives a various number of examples, as we can see set up at the top of page 10. And going, if I may, just down to paragraph 29, it says this: the principle considered above ought to apply equally to other cases where the benefit attained by the defendant has been wholly restored to the loser. In such case, a confiscation order which requires him to pay the same sum again does not achieve the object of the legislation of removing from the defendant the proceeds of his crime, but amounts simply to a further pecuniary penalty, and in any ordinary language, a fine. And then finally, at the bottom of page 10, towards the top of page 11, paragraph 34, it goes on to potentially consider those other cases of disproportion, including the case such as we have here. And it says in the bit that's put into italics at the top of page 11 of the skeleton submission, counsel submissions also touch very likely on cases of employment obtained by deception, where it may well be that difficult questions of causation may arise, quite apart from any argument based upon disproportion. These issues were not the subject of any argument in this case and must await an appeal, and which they directly arise. And of course here we are dealing with that situation. So we say that the position is in fact relatively stark, that we are dealing with here, so far as Mr. Andrews is concerned, as an individual who in effect by the Court of Appeal is being allowed to deduct the cost of his crime.
What do you say about the other example, italicised? The trade induced by deception, full value given for goods and services.
It is in effect in a case akin to sale, similar in effect where bribery was paid, and in those circumstances we say it is the same position. We say that sale in effect was wrongly decided, that the work that they did as part of that contract was in effect part of the criminal offence, because the object of paying that bribe was to get the monies from those contracts.
There appears to be in the judgment of Lord Walker and Lord Justice Hughes Lord Hughes at paragraph 34 an assumption that in a trading case, for example, a deception or bribery case, that it may be proportionate to remove the profit, and the question is whether it is disproportionate to take more than that. That seems to be the thinking. As I understand the Crown's case, you're challenging that analysis.
Well, we understand the reasons for seeking a middle way, yes, as occurred in sale. And that is not to say criticism is found on the basis that it was introduced to meet that concern. But notwithstanding that, we say what occurred in sale was in effect that they were being allowed, because they paid the bribe, the object of their criminal intent was to get the monies from those contracts. And for those reasons, we say that case was wrongly decided. Now, we understand, and I'm going to come on to, if I may, in due course, those concerns where you have individuals or indeed corporates who have done work, and how the courts in reality are supposed to address those concerns, the risk that it seems unfair, disproportionate to, in a situation, for example, in Mr. Andrews, that someone works for 10 years, and how that is supposed to be addressed. But if I may come on to that in due course.
If we just take sale, your submissions would lead you to say that the whole of the 1.9 million, I think it was, should be the subject of the confiscation order.
Yes.
That, I think, might seem rather excessive. Admittedly, bribes were given, but to then take away the whole value of the contract, the whole contract price being paid, even though the profit element is only whatever it was, 300,000 or something.
Yes.
Why isn't that disproportionate?
The individuals, when they pay that bribe, they're paying that bribe with the intention ultimately of retaining the monies from that contract. They know in paying that bribe ultimately they're not entitled to those monies. That is the object of their criminal design. It is an expense that they are willingly accepting that they need to bear, and it is part of, although they weren't charged with deception in that case, but it is part of the continuing deception, part and effect of the criminal offence, that they have to do the work. It isn't akin to for example, MTIC fraud, where very large quantities of paperwork and indeed legitimate trade is carried out to give an aura of legitimacy in relation to ultimately secure the funds in question, to get a repayment from HMRC. So we say where that is occurring, where a bribe is paid, that is in fact part of the continuing, in effect, part of the continuing offence. And it is not disproportionate, because if one considers it from the point of the individual, the corporate, they know that they paid a bribe. They know the only way that they're going to obtain the monies is by doing the work. That is a cost of their crime, to ultimately receive the monies. So, just, if I may, just returning to our general principles, as we say, this is not a case of genuine restoration. The work that Mr. Andrews did is part of that criminal offence, and as we say, restoration would involve the restoring of the actual salary. And as I say, what we say is occurring in relation to Mr. Andrews, it's allowing him to deduct the cost of his criminal offending behaviour in determining the value of his gain. And we,
sorry, I beg your pardon. I'm sorry for interrupting.
I'm conscious I'm repeating myself, but
is it right to say, as the Court of Appeal did, that these were positions that this individual was otherwise entitled to hold? He may have secured them by his fraud, but he was entitled to hold the positions. There was nothing preventing him from carrying out the work and, in due course, carrying it out to a high standard.
Well, certainly the later jobs that he entailed in terms of the positions with the A&H Trust, he had to make applications, and there was slightly differing deceptions that took place. And we say that the issue that your Lordship has touched upon, in fact, goes on to that. The first element of why I was referring to was that issue of causation, which we see is actually the issue that should be in play here, not actually the issue of proportionality. That this was so far as he was concerned, a continuing deception, continuing operative deception.
There's no doubt that if as I understand it's accepted, that if the deception had been discovered at an earlier stage, he would have been instantly dismissed.
Yes.
Nevertheless, they were positions that he was entitled, and I say entitled here in the broadest sense, entitled to hold. I mean, had he presented himself at his true qualifications, there was nothing to prevent the relevant employers from taking him on to do each of these jobs.
Well, I think what was said, certainly from the witness evidence, is that, of course, had it been discovered, because of the nature of the positions involved, that he would have been removed from office. So maybe I'm being slow over your Lordship's meaning in terms of entitled, but it's certainly, it's...
What I've got in mind is paragraph 98 of the Court of Appeal's judgment at EF 123.
Yes.
And whether or not you challenge the sentence there in the middle of that paragraph, that while he'd obtained the positions dishonestly, they were positions that he was otherwise lawfully entitled to hold.
Yes, as a matter of law, in terms of, for example, by way of comparison, kind of a Scherzen or a barrister or something of that nature, we're not suggesting that it fell into that category.
Yeah.
What we do say, though, that particularly in relation to the trust positions that he applied for, that required him to enter into as a trustee in relation to the trust. Whether that infringes what your Lordship is referring to in terms of entitlement, as a matter of law, he wouldn't have been prevented from being a trustee, but there was various requirements of acting as a trustee, which we say were very much engaged and which he fell a long way short of.
Thank you.
I think that's getting at, isn't it, the situation where the actual performance of the services is itself illegal.
Yes.
So if you had an illegal immigrant not entitled to work at all, that would be a situation where no lawful entitlement to hold the position. I think that's the sort of contrast that's been drawn here, because they've earlier referred to the surgeon example, where somebody carries on being, performs the services of being a surgeon without any surgical qualifications.
Yes.
Must be illegal.
Yes, and I think that was a justifiable position, an attempt to draw a line somewhere in relation to these types of cases. But we say in relation to that in fact, those, which I'd like to expand further, which actually was a question of causation and operative deception. The fact that somebody is prohibited as a matter of law makes it far more likely that he's operating under an operative deception, as opposed to somebody who, I think the example is given in my learned friend's argument about who's somebody who mildly embellishes their CV. In those circumstances, whether somebody is acting under an operative deception and whether he is found guilty of that offence and or sets out a basis of plea which says, well, yes, that may initially have enabled me to get the job in question, but after a very short period of time, that deception was no longer operative, and therefore the Crown are not entitled to recover the full period of, for example, of, say, my 10 years of employment. But that line, we say, and I'm going to come back to this, is something, and we understand the reasons for having it, but is an arbitrary one. But again, if I can come back to that, to develop that in due course. So as I hope I've made clear, we say that we fall into wire, that it really is the former comment, the question of causation, and not a question of proportionality. Ultimately, in this case, the position as it remains, if it remains as it is that Mr. Andrews is allowed to keep the object of his criminal conduct, namely the salary, which we say is contrary to the clear principles behind the confiscation regime. And that's set out, and I'm not going to repeat it, at paragraph 22 of our skeleton. In fact, having indicated I wasn't going to turn to it, it may in fact be helpful if we do.
Just taking you back, if I could, Mr. Brown.
Yes.
I do apologise.
Not at all.
To the illegal immigrant and to the surgeon who isn't really a surgeon at all.
Yes.
And so the surgeon who isn't a surgeon at all is committing a crime every single time he pretends to operate.
Yes.
The illegal immigrant commits a crime, presumably every time that they work.
Yes.
And I was just trying to work out how you treat, say, the illegal immigrant as a shelf stacker for 10 years and actually performs that remarkably well.
Yes.
And without any downside at all, the employer gets genuinely is pleased with the employee.
Yes.
But both of them, you say, have to forego all their income. Is that right?
I think, no, we're not. What we're saying in those circumstances is that whether that individual who has initially obtained the job by carrying out a deception and then works and subsequently provides good value, whether in those circumstances, A, would he plead guilty or be found guilty in relation to the underlying offence, in other words, obtaining property by deception, which is the most, in terms of CV fraud, that's what we are really talking about. And in those circumstances, the first question would be, am I guilty of that offence or not? That would be the first proper filter. And I confess this wasn't particularly focused on, perhaps through our fault, by the Court of Appeal, but that would be the first proper filter, whether actually what he's doing is actually amounted to an operative deception. Did he actually obtain those monies, the salaries that he was paid as a result of his lies, or was it actually because he provided good service for 10 years? But let's say, for example, he then goes on, he accepts in relation to that example, well, look, I accept that my initial lies, I said I had particular experience in shelf stacking or the like, obtains the job, and then there would be a basis of plea, would say, well, look, I accept my initial deception, got me the position, but thereafter, that's not the case. And furthermore, you need to establish that I obtained those, pursuant to the confiscation regime, that you obtained those funds as a result of my criminal conduct. So that he would be allied with potentially a basis of plea, which would set that out, and alternatively, he would say, well, look, I'm putting you to proof in relation to the issue of causation. And that would act as a double filter. And it was only in those circumstances, if that double filter had not worked, that potentially one would look at the questions of proportionality. But we would say in those circumstances, those two filters would in effect do what is contended for here in relation to proportionality, and that proportionality is not engaged. I'm sorry for the length of that answer.
At the moment, I can't see why the illegal immigrant doesn't continue to obtain the benefit throughout the whole period of employment.
Well, if the illegal immigrant, if he is an illegal immigrant and is prohibited from working, in those circumstances, it's arguable that the deception was operative throughout that, for example, 10-year period. But in relation to the individual who was not, per se, committing an individual criminal offence, for example, the prohibition on practising as a barrister without being properly qualified, or a surgeon, or whatever the case may be, in those circumstances, or if you have, to give the example quoted, I think, in the Court of Appeal, if you have an individual who embellishes what he says, in those circumstances, the proper filter is that of whether the person is actually guilty of the offence, or whether the Crown have established that in causation terms that he falls foul of the confiscation regime. But in terms of bringing this appeal, as I've indicated, the perhaps understandable concern of the Crown is that individuals such as Mr. Andrews, knowing that they have carried out a deception, then thereafter knowing that they have to do the work to get the monies, which is the object of their criminal deception, are allowed to keep it. And we say, as I indicated earlier, that's clearly contrary to the clear principles behind the confiscation regime. And just turning to, if I may, forgive me, paragraph 22 of our skeleton, and rehearsing what was set out in box. It's set out there, and the meaning is given in relation to disproportionate. In the context, it means that the order must be disproportionate to the achievement of the statutory aim, recovery of the amount the defendant has obtained from crime. In almost all cases, an order made in accordance with the provision of the Act will satisfy that test. But of course, it does go on. In some entirely different situations, that may produce disproportionality. And I suppose what we take from that, and I think it was echoed in ways, that those cases where proportionality is properly engaged are rare ones.
Yes, I mean, the drug dealer whose sole income is from his nefarious activity, or the bank robber who is found with a lot of loot.
Yes.
There isn't really much of a proportionality exercise to be applied.
No.
Because you look at the benefit and say, why, having regard to the statutory aim of disgorgement, should the whole sum not be taken away?
Yes.
Here we're in the more difficult situation, as you recognise, where someone has been employed for a prolonged period of time and has performed the duties largely satisfactorily, but as I fully appreciate, wasn't the honest and upright person that the employers were looking for.
No.
And that will have had adverse consequences on them when this was all discovered.
And we say that work that he did and the work that the corporate does in relation to the contract is a cost of their crime. It is no different from the drug dealer who rents a large warehouse, who employs staff to carry out the work of drug dealing. That is all part of a cost of his, and he knows that with respect at the time that he carries on. He knows at any point, in all likelihood, that he would be dismissed. He knows he's carried out the initial deception, which is submitting the false curriculum vitae. And in order to get what he needs, he has to carry out that criminal behaviour, in other words, working. And furthermore, we say he also knows he needs to carry out to a high standard. Just as you have, for example, the MTIC fraudster, whose documentation is impeccable and is frequently adduced before juries up and down the land, that it has all the aura of legitimacy, and this is a legitimate businessman. Well, it has to be, because if the work done is not of a high standard, and if the documentation, in the case of the MTIC frauder, is not of a good level, then the very real risk is that it will be found out, and the object of their criminal intention, the monies, is thereby removed from them. We acknowledge and we agree that there is a relationship between the deprivation of property and the legitimate aim of which is sought to be realised. But as it was acknowledged in Paulette, and it's set out again in paragraph 26 of our skeleton, a wide margin of appreciation, forgive me, I moved to that fairly quickly, but a wide margin of appreciation is given to prosecuting authorities in determining that relationship. And we say, and I know my learned friend wholeheartedly disagrees, but the legitimate aim here is the removal of those salaries, which was the object of his criminal design. My learned friend has quite properly referred to a large number of civil cases where recovery by an employer is not possible. But of course, your lordships would have noted our, in effect, retort in relation to that those cases can in fact be distinguished because they are focused on loss to the victim, whereas clearly the statutory regime that we are dealing with here focuses on gain to the individual. So while they provide, and I agree with what my learned friend says, while they provide some indication, they are plainly not determinative because of the differing approaches that are taken in relation to the different regimes in terms of criminal and civil.
So am I right in thinking, just going back to your drug dealing example, that you see no distinction between whether the work being performed is itself legal or not? So it might be said against you, well, the reason why a drug dealer can't offset the cost to him of acquiring the drugs is that the actual acquisition of the drugs is itself, the dealing in the drugs is itself illegal.
Yes.
And therefore there's no legitimate value in that sense. Whereas here, we're talking about services that have a legitimate market value.
They do, but what we also say, the services provided here were part of the deception, and in that sense, they were criminal.
So you aren't drawing any distinction?
Well, I need to be a little careful because I think those who instruct me wouldn't want me to abandon any form of line in terms of, and we understand why the Court of Appeal imposed that line that they did in terms of cases of pure illegality in terms of surgeons and the like. And I would not in any way seek to abandon that line if there is to be a line. But here, as I say, we say plainly that that deception, if one looks actually what his deception is that it's the telling of the lies in the CV and it's doing the work. That is part of the deception, because without doing the work, he doesn't obtain any monies. So to that extent, to answer your lordship's query, the work that he is doing, although not strictly what members of the public perceive as illegal in nature, it is illegal in nature from his perspective, because it forms part of his criminal offence. If the position is, if he hadn't done any of the work, there would be simply no prospect of being able to bring a criminal prosecution because he wouldn't have obtained any monies. So I suppose to summarise what I've indicated is that we say per wire that proportionality is engaged in rare cases, in cases of genuine restoration. In other words, here, where the monies themselves are actually returned. Now, the courts, including the Court of Appeal, have a clear and justified concern, we say, for those de minimis type cases where the initial deception has in fact played no part in continuing an individual being paid their wage. But we say, in effect, that they are addressed by those two mechanisms, by those two filters. First, either the Crown, through the mechanism of the CPS, or indeed the individual as properly represented, or indeed a jury, may not accept that the deception is operative. And as I've given previously, the example of an individual who mildly embellishes his job application, he may argue that he's not guilty of the offence because his lies, frankly, did not result in him being paid that salary. He may have obtained it anyway. And then second, an individual may accept that the deception was initially operative, but then seek to argue that it ceased to be operative after an initial point. The sales assistant who lies to get the job, but then is proved to be very capable of it. And in those circumstances, whether any confiscation order is made at all is open to debate. And as we say, those two mechanisms available to all should prevent those cases where the courts are concerned that there is a risk of injustice.
In most of those cases, presumably if deception is discovered, the employee will be dismissed. Is there not a continuing deception in that sense?
I think in those circumstances it depends. Forgive me if I haven't acknowledged the thrust of your question, but I think it depends on what happens with that individual. So if an individual, their deception is not initially, and they continue to work and they're offering good value, in those circumstances he may fall into that second category. In other words, he argues, look, I accept that I'm guilty of the offence, but thereafter, A, via a basis of plea, this didn't come into play, or B, you haven't established that I've obtained the monies by my deception.
Right, but there was a finding in this case that if the employers had discovered what had happened, he would have been fired.
Yes.
It's quite likely that will be a finding in most cases.
Yes.
And what I'm suggesting is that maybe that indicates there is a continuing deception even in the examples of cases you've given us.
Yes, and I think, and quite properly, that point is not taken by my learned friends in terms of causation, that it is accepted here that there was a continuing deception, and therefore we say a confiscation order should follow.
I had difficulty with the filter. You suggest there's a filter in the sense of the criminal offence being limited over a shorter period of time. But if somebody is prosecuted for obtaining a job by deception, does a prosecution usually limit that to a particular period of time? In the sentencing exercise by the judge, it might be that it was the employer might come along and in mitigation there might be some submission that the employer would still have employed the employee after demonstrating that they did the job well. But I don't see how the criminal offence operates as a filter apart from that sentencing discretion.
Well, as I say, if it is no more than a minor embellishment and he is charged in relation to that offence, in those circumstances, no doubt properly advised, and no doubt with all parties having more in mind this case than previously, and I confess I fall into that category. Having that in mind, the live question will be, look, you accept, don't you, that you initially did this and that got you the job, but thereafter, do you accept that resulted in you continuing to be paid a salary? Or is it, as was suggested here, that in fact you were doing a good job, and in fact it had no part to play. Now, in those circumstances, it would be the second of the two filters. He would be guilty of the criminal offence, but he would set out a basis of plea in which it would be argued, look, I accept that I'm guilty of the offence, but I accept that it's limited in this particular period of time. And furthermore, when it came to confiscation, of course, it would be incumbent upon the Crown to establish that he had obtained. And in the course of those confiscation proceedings, if that is what the defendant's case is, it would be upon him to make that line of argument, to say, look, I accept this is what initially happened, but it wasn't, I provided good value. So most of these cases, we suggest, would be resolved in the form of causation and not in the form of proportionality.
The defendant would have to say, well, I put this embellishment or this deceptive fact in my CV.
Yes.
I got the job, but I did it jolly well. And had my employer known about this after a month, the employer would have said, well, it may have played a part in you getting the job, but I'm now satisfied that you can have it anyway. Is that what it comes to? That's
the line that would need to be taken. And in those circumstances, I mean, to be fair to Mr. Andrews, as occurred here, that generally the observations in terms of his employment, although we contested it, in fact, not realising the full implications of what was being contested or not being contested, there wasn't an akin to a Newton hearing as to whether he did provide good value or not. I'm not proposing to try to reopen that here today.
It's accepted in the context of this case that had it been discovered at an earlier stage, he would have been dismissed instantly.
Yes.
Is that right?
Yes, that is right. But in this case, you know, it's fair to say that there were some favourable reports indicating, and in another case, one can see an individual saying to his representative, look, it's fine, but actually proof of the pudding, and forgive me using this expression, proof of the pudding is I was there for 5-10 years. I must have been doing something well. Otherwise, I wouldn't have been able to. So yes, I accept there was an initial deception, but it didn't continue.
So in effect, you're relying upon Section 76, subsection 4 as the filter?
Yes. And in effect, what we're also saying...
Not applicable in this case, but,
no.
But you're raising that as a potential filter in other cases?
Yes. And as I say, it is a double filter, because one has the option of dealing with a criminal offence, but then also one could even say there was a triple filter in place. So firstly, you have, does someone plead guilty or not to the offence, or found guilty or not? If it's a very minor embellishment, they may not be found guilty, or they may not plead guilty. If, however, they are found guilty, they then have the option of drafting a basis of plea, because they can say to their representative, the position is initially yes, but it wasn't continuing. And then finally, it's incumbent upon the Crown to demonstrate, the burden being on the Crown, that they did obtain. And that would be the third filter from which it would fall away. And what we actually say is, what was said, the dicta and why, it was actually the issues where they referred to the difficult issues of causation. That is where the battle lines should be properly drawn. And judges up and down the land, experienced as they are, making factual findings as to what an individual, whether there was an operative deception or not. Because if there isn't, and they make such a factual finding, the Crown are going to be in very real difficulties in proving that he obtained the proceeds of his criminal conduct. So, pursuant to paragraph 6 of our submission, where we make reference to the Court of Appeal, understandably, we say, reflected by this genuine concern that the shelf stacker or the man who works in the shop, despite an initial deception, will get hit hard by many years of a confiscation order, made that assertion in the employment context in particular, in cases of what is known as CV fraud, prosecuting authorities may need to reflect long and hard before deciding on confiscation proceedings.
Which paragraph? I'm so sorry.
I'm so sorry, my lord. It's paragraph 6 of our skeleton. And it's also found, I think it's EF31. I'm very grateful to my learned friend. What we would say in relation to that is hopefully by the time one gets to that stage of considering confiscation, that the factual issues between the parties in terms of whether there had been an operative deception or not should have been resolved. And where the Crown would need to think long and hard would be in those cases where there has been genuine restoration. In other words, to take this through, if I may, to its logical extension, if you have an individual who has, as part of his initial deception, then carried on with a continuing deception, he continues to obtain the monies year in, year out, we'd say in those circumstances it is not disproportionate to have a confiscation order in the full amount, because there hasn't been genuine restoration, and moreover that it's an operative deception, so it forms part of his continuing criminal conduct, and he or she may know that. I say may know that, will know that.
So, in effect, the legal immigrant who works for 10 years as a shelf stacker probably doesn't have a causation argument available to him.
If he was per se, in other words, he follow the immigration legislation, in those circumstances, that's where we'd say that there should not be a line. If there's going to be a line, we'd say, please have that line. But if there's going to be no line, we would say in relation to that is indicative of the fact that the deception is an operative one. But that is not to mean that he could not argue that causation has not been properly established.
But, I mean, if he's presented himself as a legal migrant, wouldn't that be an operative representation, just like it is in this case, that that Mr. Andrews had the qualifications which he didn't have?
Yes.
What would his defence be?
It would be more than likely in those circumstances that if you had somebody who was working illegally, that the deception would be operative. Would your Lordship just give me one moment? Forgive me. Yes, I mean, to extend it and put it, if I may, in a sort of reverse way, is that if one considers the reverse of that position, only, and it's in fact surmised in our skeleton, that only if there's a legal bar will it not be disproportionate, as a person without the necessary qualifications cannot lawfully give value. And we say, in fact, we ask the question, and we've asked it in our skeleton, why does proportionality not work here? If a person has worked for 10 years as a surgeon or an airline pilot or a barrister without qualifications and has given good value, why would it not be disproportionate in those circumstances to make an order? And so we say, if you look at it in the reverse...
So why would it be disproportionate?
Sorry, did I say why not? Why would it be not disproportionate to make an order? In other words, the reverse. Somebody may be an illegal immigrant, but have provided good value for 10 years or so. And in those circumstances, that drawing of a line, we say, is something of an arbitrary one. We understand that the reason that the Court of Appeal thought it was appropriate. But actually, that individual may have given value for 10 years. Why should he not be entitled to say this is disproportionate? I've given value. It's simply because I wasn't. Well, in effect, what difference does that make? The fact that he is not lawfully entitled to work, or the fact that he's not properly qualified as an airline pilot or a barrister, may be a good indication that there is an operative deception. But I suppose just to flip the argument on its head, we say that does show the arbitrary nature of that particular line.
You say there's no distinction to be drawn between
we say no
any of
distinction.
these.
No. We say it is a question of causation.
Well, could I put against you that I think the rational answer to what you're asking is that those people are not entitled to be paid for that sort of money, for that sort of service. It's illegal for them to be paid. They're providing nothing of value that the law recognises.
Yes, and
that is the difference. Here we have work being performed that is recognised to be lawfully performed work, and to which one is normally entitled to at least market value.
Forgive me, I think I probably made the point, but we of course say, yes, per se, it is lawfully performed work, but we also say it's work carried out as part of a criminal offence, and there is a distinction to be made.
I understand your point.
Yes, forgive me if I'm...
You were indicating that leaving aside causation issues, why on one side of the line might it be thought disproportionate and not on the other side of the line? And I think the answer is that on one side of the line there's no value that's actually passing.
Yes, and they may well be guilty of a criminal offence in their own right, and no doubt they would be for working in this situation. So we understand the reason, but we say that it should not necessarily be a hard and fast line to be drawn in the sand if one says that proportionality does work. And we say what drawing that line in the sand actually does is obscure the real issue here, in that the individual has not provided good value because the work he performed is part of the criminal offence, allowing the criminal to take off the cost of their criminal conduct. If I may I touch upon...
Terribly sorry, Mr. Bradford.
Not at all. Not at all.
But the disproportionate exception in section 6, subsection 5, does that require the defendant to establish his disproportionate? I think you can find the actual provision at page 109 and set up paragraph 33 of the judgment.
Forgive me, I've just got a slight tickle. May I reflect on that question and come back to that in due course? That's not to say I'm dodging the question, but I'd just like an opportunity to have a think about it. Can I, and at this point, I don't know if it was assistance, I hope that it is, to touch upon a number of points that are made in my learned friend's skeleton argument. Certainly, my learned friend deals with the issue of, and if I can just take you please to paragraph 5 of his skeleton. Quite properly sets out the history of the legislation, and paragraph 5 deals with the Drug Trafficking Offences Act in 1986. And we say, in fact, this particular passage is, in fact, set out there at paragraph 5. Is, in fact, a passage which is fairly helpful to the appellant. And where it refers to, forgive me, net profit. Forgive me.
The accounting exercise.
Yes. Yep. Net profit derived from the payment after deduction of expenses, whether the expenses are those of purchase, travelling, entertainment, or otherwise. It seems to us that the section is deliberately worded to avoid the necessity, which the appellant's construction of the section will involve, of having to carry out an accounting exercise, which would be quite impossible in the circumstances of this case. And that is exactly the words, phrased in a slightly different way, echoed by the recorder in the lower court, that trying to attempt to carry out some form of exercise to quantify the work done to find some form of middle way which occurred in sale to which allowed a profit margin is in fact suggested here that is very difficult to do. And the hard and effectively fast rule that's set out here was that it's impossible to do and should not be done. And we would say the types of expenses, purchase, travelling, entertainment, or otherwise, are exactly, the or otherwise is exactly the type of expense here. It's an otherwise type offence, and the problem is that engaging in proportionality, what is proportion, how much should we knock off in relation to the many years as the recorder was seeking to do, it is exactly the type of accountancy exercise that courts properly have sought to avoid by looking properly at the issue of causation.
So do I understand your submission also to be that unless restoration is complete, you don't take it into account at all?
Yes. In short, yes. What we say here is that pursuant to the statutory regime, in circumstances where the object of their criminal offending behaviour has not been restored, in other words, the salary, we say that it's not engaged. We agree that the reference to deterrent effect is something which is incidental to the confiscation regime, and that's set out plainly in my learned friend's argument. That is not to say that it does not have a considerable effect, and it will not come as any surprise to your lordship that in relation to this case, there are a number of cases being looked at by the Crime Prosecution Service which are in effect on hold. This is not CV fraud. I'd like to avoid any, not necessarily it's been made, but any suggestion that it is growing in prevalence and it is of significant value. And in fact, those who instructed me conducted an exercise, and there are a number of cases which are in effect on hold, pending. That is in no way, and I hope it isn't taken as such, to hold a gun to your lordship's head, but the point I seek to make is this is clearly a very significant issue. What's set out at paragraph 8 of my learned friend's submission, we wholeheartedly agree with. It's not and we agree that it's not the essence of the legislation. It is incidental to it.
Again, sorry for interrupting, but I'm just trying to think through what your proportionate test, and the criticism is that it's self-fulfilling insofar as it's very hard to imagine situations where it wouldn't be disproportionate. The only one is full restoration, okay? And that would mean that Lord Hughes in Ware, where he said that there may be other cases of disproportionate analogous. What are those cases? What are the other situations where it may be disproportionate?
I think on the basis of the way that I said our case, it's difficult for me to come up immediately standing here as an example for your lordship. Certainly all I can say in relation to this case is that full restoration would be required. And I know that is the criticism that is levied at us, that it allows no scope. But what we say is that in relation to this particular case, that proportionality is not effectively engaged. Now, I'm not going to say that there may be not other cases where proportionality would not be engaged that did not necessarily involve full restoration. But certainly in this particular case, we say, as I say, this is a causation argument and not a proportionality argument. I appreciate that's not a wholly comprehensive response to your Lordship and quite proper inquiry. But
And when you say full restoration, I assume you're including partial restoration. In other words, if this defendant had given back 3/4 of the salary.
yes,
Yeah.
yes.
And if he said, well, I won't pay you back 10,000, but I'll do some work for you.
I think on the basis if he'd already done the work in the first place, and in those circumstances that had been part of his continuing criminal offence, if he then returned at a later point, I could see in circumstances that might amount to restoration. But it is different, we say, because at that point he would no longer be operating under a continuing deception. That is, it is akin to certainly attempting to make restoration. But I am perhaps understandably nervous about advancing that proposition, because ultimately the object of his criminal intent is to get the monies. And that is where we say that the statutory regime comes into play, that by allowing him to work off, as suggested by your Lordship, in fact defeats the object, which is a proportionate object, of those monies being repaid, the actual monies being repaid. Could I please turn to paragraph 19 of my learned friend's skeleton, where it makes reference to, forgive me, the case of Bolchevich in Croatia. It may be my observation, just in the way that my learned friend has phrased the factually adjacent. We do not say this case is factually adjacent. That case involved an individual who failed to declare his monies when entering Croatia. And of course, he was fined 10,000 kunas and made subject to a €180,000 confiscation order. At no stage had the government in that case sought to argue that the euros in question, which were deposited, came from money laundering or crime, unlike in our case where we say it does come from crime. It's right to acknowledge that it was confirmed that it was not a proportionate order, as the interference did not correspond to the severity of the infringement. One wonders what the position would have been if it had been established that that €180,000 confiscation order had in fact been the proceeds of money laundering or some such. May I also turn, please, to paragraph 24 of my learned friend's submissions. And I have no doubt my learned friend was attempting here to provide a helpful example, a factually simple example, analogous to demonstrate, as he sets out at the start of paragraph 24, Searle and Andrews. In fact, we say, unfortunately, the example that's given is not actually on point. In fact, to be closer aligned would have been, in fact, the example of the dishonest person who lies to get employed in the shop and then is paid a wage. The difference here, in terms of the example that is given by my learned friend, is the goods are actually paid for. And here, by way of example, Mr. Andrews has not paid for the goods. Here, the individual who lies or pays a bribe has not obtained the property in question by deception. He has got into the shop by deception, but he's not obtained the property by deception, as he's not paid for it. He would be treated differently, as he would not be guilty of the criminal offence of obtaining property by deception. In any event, even if he had pleaded to it, he would be able to use as a basis of plea to argue that he had not obtained that property. So we say that the example given here, and I understand the sentiment in which it's set out in an attempt to find a close example, but it is not on point because it in fact involves the person paying for those items, which did not occur here. And so that deception there would not have been an operative one.
So there's but-for causation for the shopper, but you say there's not a sufficiently direct link between the his deception and the obtaining of the goods in the shop.
Yes, the causation aspect comes into play, and because it comes into play, proportionality is not engaged. And just dealing with what is set out at paragraph sort of 7, we say it's putting the cart before the horse. Proportionality is not engaged because he's not obtained anything in the shop if he's bought the items. The offence of obtaining the deception, for example, of obtaining property by deception, for example, indeed the confiscation regime, are not engaged. If charged with bribery to get into the shop, where he may have committed offence, whether he had obtained the goods in question per the confiscation regime would be very much up for debate as part of the confiscation process. Unlike the case here with Mr. Andrews, where the obtaining is actually the criminal offence, so it's directly aligned with the confiscation regime. So there, in a case, for example, if he'd been charged with bribery, he pleads guilty, and then it's alleged, well, you also obtained those goods. In those circumstances, we say the confiscation regime would be engaged.
Where there is no causation defence, as for example in the case of the illegal migrant who was unlawfully employed throughout, in that context, would there not still be a proportionality question?
On the basis of a migrant who hasn't been able to overcome the causation hurdle, we would say in those circumstances, no. For the illegal immigrant who has worked for a number of years, knowing that he's prohibited from doing so, we would say he would not be able to avail himself of proportionality. But that is not a hard and fast rule. It is obviously, it would need to be looked at in every single case. The fact that he is working illegally is a likely indicator that there is an operative deception. It does not necessarily mean that there would be, and it's a case that would need to be argued as he's thought fit. He may say, well, look, yes, I was prohibited from working, but notwithstanding that, I don't say, notwithstanding that prohibition, that I was not able to, that I should make full foul of the full confiscation regime, that you've established that I've obtained any monies as a direct result of what I did.
I have difficulty following that, I must admit, because it's illegal for him to work, and it's illegal for the employer to employ him.
Yes.
So the employer can't say, look, after a number of years, I'm going to employ this person because he's working extremely well. And so accordingly, unless I've got it wrong, there must be an operative deception throughout the entirety of the employment. And the only method by which one can deal with whether to confiscate the entirety of his earnings would be through disproportion. And so I don't understand at the moment as to why it wasn't an operative deception throughout.
may I say two things? First of all, it may be one of those that I'd appreciate the assistance of Mr. Evans. That's not the phone a friend type defence. But can I say this, that it is something that requires some further consideration, perhaps by me. But I think I agree with what your lordship says, that it's hard to see circumstances where somebody is prohibited as a matter of law for never being able to argue that it wasn't causative. I agree, and I'm not seeking to dislodge that. But I am potentially saying we need to be careful about necessarily introducing hard and fast rules. It is likely in those circumstances that it would be causative. But I don't want to rule out the type of situation that none of us can think of, and this, well, certainly I can't think of at this particular moment, where it may not be. But again, it may be, if I'm allowed the opportunity to do so, that I can come back to you in a written submission just on that particular discrete point. Can I just turn, if I may, now to paragraph 29?
29 of...
Forgive me, my learned friend skeleton argument.
Yeah.
Thank you. Before I do so, is it your lordship's intention to rise at 1 o'clock? Is that the intention, or is it?
We'd rise at 1 o'clock, but
yes.
if you're pressed for time, we will sit again earlier.
I'm very grateful. I just wanted to confirm what time you'd be rising.
Thank you.
Here, my learned friend, at paragraph 29, deals with, in fairly brief terms, it was not contrary to public policy, and the statutory objectives for his performance of his roles to be treated as analogous to full restoration. We say, in fact, that is a major concern so far as the Crown and other prosecutorial agencies are concerned. The public policy here is very much engaged, because ultimately CV fraudsters are being allowed to keep the object of their schemes. And potentially, I suppose it could be argued that the second weakness in relation to proportionality is that it engages on cases being decided on a case-by-case basis with regard to the principles of proportionality, as opposed to judges up and down the land making findings of fact in relation to causation. And we say, really, proportionality is at the end of the line that seeks to address those cases where there is a rare possibility of injustice being done. And here, by pleading guilty to obtaining property by deception, and where it's acknowledged there is a continuing deception for many years, proportionality does not come into play because there has been no restoration. The work done was a necessary element of that deception. Doing the work here is not, I'm conscious this may be somewhat repetitive, but doing the work here is not true restoration and subverts the statutory aim. Just if I may, turning to paragraph 52 of my learned friend Skeleton, please. The learned recorder in that case did make that value judgment where he observed that few would regard as proportionate and ordered that deprive the respondent of the whole of his earnings for 10 years. All I can say in relation to that is that he was not addressed in the way that I have addressed you now in terms of the filter of causation. because we say that many people would regard as proportionate an order that would deprive a respondent of the whole of his earnings for 10 years, where he had to do that work in order to complete the criminal offence, where it formed part of the offending behaviour. I think, quite understandably, as the learned recorder did in that case, that it is easy, we say, to fall into potentially the trap of looking at this case and simply saying, well, he'd worked for 10 years. It's very unfair in those circumstances.
Forgive my ignorance, but can you just remind me, he was charged with precisely which offences?
Obtaining by deception, forgive me, but because his offending behaviour spread over 2 different time periods. I think it was initially obtaining it and then something under the Fraud Act. Could I come back to that directly?
EF 223
I'm very grateful.
is the indictment.
Thank you.
223.
EF 223.
And did he plead guilty to all of them or not?
Yes.
What I was just wondering was, under an offence of fraud as such, as opposed to obtaining property by deception, whether what you've just said, I understood your proposition to be,
Yes,
in the way you just expressed it, that the work was, in a sense, part of the definition of the crime because you're obtaining property, i.e. the money, by deception.
yes.
And I was just wondering whether there were other formulations of offences where that would not be so clear-cut. But I may be on a false premise.
Well, I mean, to take the case of sale, I suppose, where obviously charged with bribery, and in that particular case, unlike here where we have certainly at count 1, that it forms part and parcel of the offence. I may have missed your lordship's point because I believe you were saying to say, are there other offences?
Yeah, can I just look at the indictment? Which page was that again?
It's 223 and 224. 223 is the first offence, which is section 16(1) of the Fraud Act, obtaining a pecuniary advantage by deception. And the other 2 charges are fraud under the Fraud Act.
Yes, my lord, yes. There was a 4th count to which a not guilty plea was entered.
Yes, which was left on the file.
I think Lord Burroughs' point is how would it apply to the fraud charge, for example?
Well, I think it's in reference to the words fraud there, looking at it. Obviously, it's the statement of the offence, but committed fraud. It's implicit, we say, from that not only, of course, there is a misrepresentation, but that is only an active misrepresentation if the work is done and the salary is paid. Otherwise, it wouldn't amount to fraud.
Well, you don't need to actually make a gain. You dishonestly and intending thereby to make a gain.
Yes, forgive me, and also there as well, to make a gain for himself or another. Without doing the work, he is not going to be able to make a gain.
But the defence is intending to make a gain. I mean, even if the NHS Trust, let us say in count 3, discovered before they paid him a penny that he had been fraudulent, would he not still be guilty of making false representations, intending thereby to make a gain? I think the answer is he would.
Yes, that's right. But in those circumstances, he may not have fallen foul of the confiscation regime if it had been discovered at an early stage. If, on the other hand, as occurred here, that it did continue thereafter.
Yes, I think my only point was that, as I understood your submission, but it may be that I'm wrong, you were making the point that in relation to obtaining property by deception, the criminal activity necessarily includes the carrying out of the work for which you are paid, because you can't obtain anything without obviously doing the work.
Yes.
And I think my point was that when you switch to a fraud offence,
Yes.
there is no linkage in the offence itself to earning anything, because the offence is committed on day one before you've actually earned anything.
Yes. Would you just bear with me for one moment? Yes. It is, of course, right that deception is continuous. It is just, I'm particularly concentrating on those committed fraud. I acknowledge what your lordship says, that on the face of it, that if he simply dishonestly and intended to make a gain for himself, in other words, if he wasn't actually paid anything, he might still be guilty of the criminal offence.
Yes.
And I agree with that.
I mean, the key in charge 1 is that you have to obtain the pecuniary advantage
Yes.
to complete the crime.
Yes.
And your argument is in such a circumstance where you have to work in order to commit the crime, there is no scope for a proportionality argument where the crime is framed as attempting to gain advantage dishonestly and fraudulently. It seems to me you have to accept that proportionality might come into play.
Yes, I obviously acknowledge the way that the particular of the offence of pleaded. Of course, that is not the way that it was set out in the opening note, that this wasn't a case where it was simply alleged that it was a representation which was dishonest and nothing came of it. It was very much pleaded in the way as set up in the opening note, which amplified what was set out in the particular of the offence that he had worked. But I take your lordship's point. What we would say is that to just pick on the final mark your lordship made, just in relation to proportionality in those circumstances being engaged, there we would say that the further filter of the confiscation regime would come into play. And so whether he had obtained the monies in question would very much come into play, because of course that effectively reflects what's set out in count 1. But we do say generally that in relation, taking just standing back, these offences, whether one looks at counts 1, 2 or 3, could not have been committed and would not have been charged but for the work that was done and the payment of it. That is part and parcel of his criminal enterprise. They do not go, whichever way one cuts it in terms of counts 1, 2 and 3, they do not exist independently, save for in limited examples where it was put on that basis. But clearly here it wasn't put on that basis. And if there were a case that it would put on that basis, then one would look at the confiscation regime to see if the Crown was proper in seeking a confiscation order. Can I deal with one minor matter? It's just set out at paragraph 64. and my learned friend is right, where he says that the recorder imposed a compensation order in favour of the 3 former employees. I think, and setting it frankly before your lordships, what in fact occurred was that those who instructed me were concerned that if a plain and simple confiscation order was made, that in the normal run of things that would be swallowed up by the Crown, as opposed to the parties that had actually lost monies. And so here, so far as the order was being made in respect of the former employers, what occurred is a confiscation order was made, and then it was framed in terms of a compensation order. Now, standing here as I do today, I am struggling to see the basis upon which that was done, but certainly that, my understanding, reflected his concern that a confiscation order would be, if it was just paid in the normal way, would be swallowed up by the Crown and not be made principally in favour of St Margaret's Hospice. And I just wanted to add, it wasn't a simple case of a confiscation order was imposed. It was in a mechanism by which the recorder, I think, was seeking to do justice to what occurred.
Yeah, I think the Court of Appeal was somewhat puzzled as to how that was compensating any loss. Hard to see that losses would amount to very much, if any.
No, I think what the recorder was seeking to do was to make them the beneficiaries of the confiscation order. Because, as I say, he was concerned. But I just...
I wonder, I mean, it seems to me, if you take the hospice case, I mean, they would presumably suffer considerable reputational damage as a result of having as their chief executive in a situation where the families will be very concerned about the last days of their loved one. They'll be very concerned that the hospice had found itself the victim of the fraud that occurred. And presumably there must have been quite a lot of work to be done to preserve the reputation of the institution because of the criminality of the respondent.
Yes, and there was a statement, in fact, to that effect, that in terms of fundraising, it's fair to say not exclusively as a result of what took place in relation to Mr. Andrews, but certainly in terms of...
They got some pushback on fundraising.
Reputational damage. One can understand why that would occur. Of course, it is not St Margaret is not it's supported by charitable funds, so it's not a government organisation.
Of course, you'd have to offset the fact that they've saved themselves quite a lot of money.
Yes.
Does a compensation order cover reputational damage?
I think we looked at that at the time, and I didn't believe that it did.
Right.
But
it might.
Yes.
Could, from my perspective, I'd be grateful if that could be added to the list as it
yes.
were, because if there is a compensation order, and if the compensation order should be reinstated in favour of the hospice, then
yes. Thank you. I'm conscious of the hour. I do. I would say I have about another 15 or 20 minutes or so. For my part, I'd be grateful for a break now, if that's possible.
Of course. If you think you can wind matters up in 15 minutes, we can probably stick to the current timetable, subject, of course, to your view whether you feel you've got ample time in the hour and 3/4 that I was allocating.
No, I'm sure it'll be fine, my lord, but perhaps we can review it as we go along.
Yes, but I appreciate that you may have an interest in a slightly longer lunch break than i.e. the full hour rather than a curtailed hour,
yes.
and I'm happy to give you that.
I'm very grateful. Thank you.
Thank you very much.